Things about CSPA, Child Service Protection Act, as the USCIS has updated its website, allowing us to be eligible if based on the filing dates. So that's the reason why we are here. Emily, can you explain what CSPA is?
Yeah, it's the Child Status Protection Act, and basically it's a special rule that allows you to kind of modify the age of a child to help them be able to file the green card along with their parents and actually receive the approval of the green card even if the child ages out or turns 21 while the process is going on. So there are some very specific requirements for it, and we have a new interpretation of it that opens it up to more people, so more children of immigrants will be able to receive their green cards with their parents.
So Emily, so previously it was only if the final action dates were current. The I-140 must be approved, the 485 must be filed, and the child must be under 21, CSPA 21. That means that you deduct the period of time the I-140 has been pending from his age. Only they were eligible to get the age locked. Now USCIS is coming and telling that it's based on the filing dates. Is that what it is?
Exactly. Yeah, so now, because when under the old interpretation, it created a problem where kids were able to file the 485 along with their parents because the filing date was current, but they never knew if their age was going to be locked in time because they have to wait until the final action date becomes current in order to determine when their age is locked and are they under 21 at that moment. Now we're only looking at the filing date. So as long as the I-140 is approved, and you're filing the 485 based on the filing date, your age is going to be locked, assuming that the child is under 21 at the time of filing, under either their actual real age or their CSPA age, taking into account how long the I-140 was pending.
So Emily, already our audiences already know that they have to deduct the age for the underlying I-140. How much ever? Let's say the I-140 is pending for 1 year. They become actually 21 when they're actually 22. Our audience already know that. Now you're telling that based on the filing date, but what happens to the application that were filed before? Normally rules are applicable from the time going forward. What does the new rule of the USCIS tell that?
Yeah, so the good thing is if your 485 is pending and you were thinking that you've aged out and instead you don't age out under this new rule, your 485 will remain pending and USCIS will adjudicate it based on the new interpretation of the rule, even though at the time of filing, the old rule was there. So they are kind of applying this retroactively to people who've already filed under the old rule.
Emily, what happens if one of the kid 485 has been denied because he aged out? Can we reopen the case right now?
Yeah, that's another great thing because they're allowing us to kind of apply this retroactively, even for someone whose 485 was denied because they aged out due to the final action date. If they would not have aged out based on the filing date, you can actually file a motion to reopen, even if it's been more than 30 days since that 485 was denied under the new policy. And so those kids can now receive the green card with their parents.
What if the cases where the individual has not filed the 485 because thinking that, oh, I am not going to be eligible, I'm not going to get the green card, I'm an F1 right now, based on the filing dates, I'm not going to get the green card, and they didn't file the 485, is there any solution for them?
Yeah, so we don't have any guidance on this. The website does not cover this exact situation, but our interpretation is if you're in the US in a non-immigrant status and you would have qualified, let's go ahead and file now and see if we can get them to adjudicate the 485. Now, there are some issues with it. We've got to get it past the mailroom. Is your date current now for you to be able to file? And then your parents may have already gotten the green card. Are we able to connect your case to theirs now after the fact? We don't know, but I think it's certainly something worth exploring, giving it a try, because you're not going to lose anything by doing that, and you might gain the green card by doing it.
What if the applicant is outside the country, has never filed the green card, now he's about 21 under the CSPA? Is there any solution for that?
Yeah, I think that one is even more difficult because there's no ability to file the I-485 application if you're outside the U.S. and we would have to get USCIS to notify the consulate that the I-140 has been approved, and then the consulate would be the one to have to decide if you're eligible to proceed, even though you're outside the US and over 21. And as of right now, the consulates are governed by the Department of State versus USCIS, which is under Department of Homeland Security. Department of State has not yet updated its guidance about using the filing date chart. So on their side, they're still looking at the final action date. So we're not sure if this is going to be helpful for people who've already left the US or are currently outside the US.
So let's go to the question, Emily, with regards to the previous CSPA interpretation to the new CSPA interpretation. Can you be a little bit more descriptive, make the people understand what it was before and what it is right now?
So before, you could file your 485 based on the filing date chart, as long as USCIS allowed that and your priority date was current. And at that time, you could include your children along with it, as long as at that moment they were under 21 based on their actual age, or based on their age if you subtract the amount of time the I-140 was pending. The problem is, once you file based on the filing date, the child's age is not yet locked. It's not frozen until the final action date becomes current. And so you're constantly wondering, while your 485 is pending, while your child's 485 is pending, that they were allowed to file, is my child going to age out while I'm waiting for the final action date to become current? And that was happening to a lot of kids. And a lot of times the filing date even retrogressed, and they're nowhere near the final action date being current. So that was the old rule. So these kids were getting denials of the 485, or they knew they weren't going to be able to get an approval because the final action date never became current before they turned 21, either based on their actual age or their age minus the amount of time the I-140 was pending. Fast forward till now we're looking at what was the age when the filing date became current. We don't have to worry about when the final action date becomes current. That could be 10 years from now, and the child could be 30 years old. They still qualify because they had approved I-140 and they filed the I-485 based on the filing date chart, and their age at the time of filing the I-485 was under 21, either based on their actual age or their CSPA age, subtracting the amount of time the I-140 was pending. Once that 485 is filed, their age is locked going forward, regardless of how long it takes the final action date to become current or how long it takes USCIS to approve the 485.
Let's run the scenario of the people who filed in October of 2020. These are the most of the people that we are speaking about, especially in the USCIS website. They commented about the October 2020. Emily, in October of 2020, the filing dates were current. The final action dates were not current. Let's run some of the scenarios, though. So I have my I-140 approved under EB3, and I have filed for the 485 in the filing dates. My child at that time was under 21. But before the final action date becomes current, my child turned 21. Is my child protected right now?
Now, yes. Previously, no.
And what if the child has actually got onto F1 visa, or maybe he has gone to move on to H1, but he has filed the 485 application along with our family? Is he protected?
Yes, still protected. You don't have to be in H4 status or in that dependent status in order to qualify.
What if my child did not file the 485 application in October of 2020 because I thought at that point of time he would not qualify anyway? Why should I file this application? I will wait for the final action date to be current. Is there a solution for it right now?
Yeah, now if the filing date is current, or when it becomes current, and USCIS allows us to use the filing date, we would suggest go ahead and file that I-485 now under that chart, and make the argument that had the policy been implemented at the time the parents filed, the child would have come under the new policy and would have filed the 485 at that point.
But you don't have any assurances that they'll accept. We
Right.
don't have any assurances that we are going to be winning.
Right.
What if the scenario is that I filed the 485 application under the downgrade application in 2020 under the EB3. My I-140 was never approved. My I-140 was approved somewhere in 2021. By that time, the dates of filing went back.
Yeah.
And I file the 485 for my child. Is my child protected?
No, that's one of the big areas for people to be aware of. You have to look at the Visa Bulletin filing date chart on the day your I-140 got approved, if you filed concurrently or your I-140 was still pending when you filed that 485. So when the I-140 gets approved, if the filing date is not current at that point, the child's age is not locked, and it won't become locked until the filing date becomes current again. At that moment, then you have to determine what is the child's age at that time, subtracting the amount of time the I-140 was pending. So it may be helpful that some people's I-140s did take a year to process. They can buy an extra year for the filing date to become current again. But that's one thing to be aware of, where just because you filed the 485 based on the filing date chart, you're not automatically locked if your I-140 was still pending.
There are 4 things that need to happen at the same point of time. They cannot happen at a different point of time. One, all 4 things have to happen in the same month. They cannot happen in a different month. The final action, the filing date is current. The filing date is current. The I-140 has been approved. I-140 has been approved. The 485 has been filed, and the child is under 21. The child is under 21 under the CSPA. You reduce the age, you reduce the time period, I-140 has been pending. All 4 months has to happen in one single month. They cannot happen elsewhere. So if the I-140 must be approved, the filing dates are current, adjustment of status has been filed, and the child under 21. All 4 has to happen at the same time. If it happens at a different time, like for example, you have the 485 filed, you have the child under 21, you have the filing dates current, but you don't have the I-140 approved, sorry, you're out of luck. All 4 things have to happen at the same time. What the thing changed right now as compared to previously? Previously, all 4 things has to happen at the same time. But previously, it was the final action dates. Right now, it's the dates of filing. That's the only main difference that happened from there to right now. So questions are coming from Anita Sarkar. What if the child changed the status to B2 and aged out? Anita, one thing is that if the child has filed the 485 application and he meets the requirement of all 4, okay? Because you're thinking he's aged out based on the final action date though. But if all 4 things happen, that means I-140 approved, 485 has been filed, child under 21, filing dates are current at one time. Even if he has changed to B2, you can still bring him back into the 485 application. They are good. Even if the 485 has been denied, you can do the motion to reopen and get this open and get the kid to get the 485, get the kid the green card.
Now, is USCIS going to automatically review cases that were denied and reopen them on their own?
No, Emily, they are not going to do that. I don't think so they're going to do it.
And how long is this new policy going to last?
I hope so forever, because it's going to be, unless some other government will come and undo it, it's going to last forever. Hopefully so.
Mm-hmm. And again, so this applies even if the 485 was filed under the old policy. And if it's still pending, great. You look to make sure they meet the rules under the new policy. That means USCIS will apply the new policy and they should receive the green card with the rest of the family. If at the time you filed, the old policy was in place and USCIS denied the 485 because of it, if your child would now be eligible, they can file a motion to reopen in order to receive the green card, even if it's been more than 30 days since that denial happened. What we don't know is how this will work for people who never filed the 485. We think it's worth taking a risk and trying it in many situations. We don't know how it will impact people who are outside the US and having to do this through the consulate because the State Department has not yet updated their policies.
Is this going to be helping with the people whose filing dates have never become current as of now?
No, but it may. So it all depends on what your child's age is now and how long it might take for your filing date to become current. So if your child, if you haven't filed the 485 yet because your filing date is still not current and your child's turning 21 tomorrow, probably not going to be helpful to you. But if your child is younger and it might, let's say your child is 10 and maybe your filing date becomes current in the next 5 years, then as soon as you file that 485, assuming the I-140 is approved, your child's age will be locked. And even if it takes another 10 years for the final action date to become current, and your child has turned 21 while they're waiting, they will still qualify and can receive the green card with the rest of the family.
Emily, what is the CSPA 21 age? Can you explain that to me, please?
So it's based on whatever petition is supporting the 485. So in employment base, that's the I-140 petition. So we take how long that I-140 petition took to be approved. You go from the filing date, the received date, to the approval notice date. How many days is that? And then you subtract that from the child's age on the first day of the month when the filing date became current. And if it's under 21, then that's their age, not their actual age. The CSPA age counts.
So CSPA age means all the time, because I-140 will take at least 2 days to get the approval, is right? So CSPA age is always different than the age, is right, Emily? So if the kid is becoming 21, so technically he won't be 21 until 21 plus the time period the I-140 has been pending. Until that period, he does not. What if my I-140 has been filed in premium processing? I got the I-140 approval in 2 weeks. And now I think so the priority date is going to move, but my son is about to age out. Is there a creative solution that you got in?
Yeah, you may want to consider working with your employer to withdraw your approved I-140, which seems a little bit overkill, but if you do that and then refile that same I-140 using the same labor certification in regular processing, now it might take 6, 8, 12 months to process. By doing that, you've gained 6, 8, 12 months in order for your child to age out. So you're delaying the time that they age out by withdrawing and refiling. It does require your employer to be in on that because they're the ones filing the I-140, but that's kind of a creative solution. Another thing to be aware of is with all of this transfer of underlying basis that was happening between EB3 and then downgrade and then upgrade to EB2 and now EB3 is ahead, you always have to look at which petition you're using to support the 485. That's the petition that you use to figure out the actual age of the kid under CSPA. So if you had an EB3 case that took a year to process and an EB2 case that only took 2 days to process and you've now upgraded to EB2, it's how long was your EB2 petition pending that is subtracted from the age. So you've got to keep that in mind as well.
Yeah. So whenever you are in adjustment of status, though, for the people who got the green card, you're good. You don't have to worry about it. For the people who have been aged out, who have been kicked out of the application or did not file the 485 application, thinking that they would not qualify, I think so it's time for you to consult a lawyer. If you have already filed the 485, you need to look into this video very carefully to determine if the age is locked. The magic word is the CSPA age locked? That's the magic word we need to look into. To do that, we need to have I-140 approved, 485 filed, child under 21, and filing dates current. If all of those 4 things are made, the child is locked. Then that's the best solution for you. Question that's come from Katie is that child is turning 21 in September. Do I need to change to F1 visa? One of the things, Katie, is that we don't know if your child is locked under the CSPA age, though, at this point of time, because we don't know if all 4 things have been met for you or not. The main thing what we are looking into missing on the applicants that were filed from October 2020 to right now is the main thing was that is the I-140 approved? At the time when the I-140 is approved, is the filing dates current? Those are the 2 main things that we are looking. Of course, your child must be under 21, you must have filed the 485, but these 2 things are what we are mainly looking at though. So if the child is locked though, I would not prefer going for them to transfer to F1 visa.
Right, yeah, because they're allowed to continue to stay even after they turn 21 based on the pending I-485 application. They can use their EAD to work, they can use their AP to travel. As long as we're clear that their age is locked, there's not much reason
to go to
to
F1
go to
visa.
F1.
Anything else, Emily?
All right, I think that is it for today. So if you are wondering if your child's age is locked or if this new policy applies in your situation, you can always reach out to us at rnlawgroup.com, and you can submit a contact us form there, or you can email us at info@rnlawgroup.com. We also have a daily conference call with the details on our website at rnlawgroup.com. Where you can join that for free, and we answer your questions there. So all of those ways you can get in touch with us, and we'd be happy to help in either filing a motion to reopen or suggesting other ways to make sure that this applies to you.
Thank you very much.